Just like the other arms of government, the Nigerian judiciary came into existence before the country attained self-rule, and by independence in 1960, it attained the status of an independent arm of government. This led to the establishment of the Supreme Court as the apex court, with Sir Adetokunbo Ademola becoming the first indigenous Chief Justice of Nigeria in 1958. The military era, however, witnessed wanton disregard for the rule of law and democratic principles, as the military government treated the judiciary as if it were an integral part of the civil service. The period also witnessed indiscriminate dismissal of judicial officers and open disobedience of judicial pronouncements. The return of democratic rule in 1999, however, brought to the fore the vibrancy and courage of the judiciary, as several landmark decisions were made by the court. This new vigor was attributed to some unique provisions introduced by the 1999 Constitution, including those providing for the establishment of two independent regulatory institutions: the National Judicial Council, NJC, and the Federal Judicial Service Commission. In spite of these positives, however, some major challenges persist. One of such is the lack of independence arising from the judiciary being tied to the apron strings of the executive arm of government, as recently alluded to by the Chief Justice of Nigeria, Justice Tanko Muhammad.
The annual budget of the judiciary is still a far cry from what it ought to be. The figure is either stagnated for a longer period, or it goes on a progressive decline. The only thing I can do at this juncture is to plead with all concerned to let us enjoy our independence holistically. If you say that I am independent, but in a way, whether I like it or not, I have to go cap in hand asking funds to run my office, then I have completely lost my independence.
The judiciary has also had to grapple with accusations and counter-accusations of bribery and corruption against judicial officers.
Our focus has been on reinventing our processes, providing speedy and quality administration of justice, strengthening our structures from the Supreme Court to other courts of records, and stamping out corruption from the system. If any judge is found wanting and there is evidence, please write your petition to the National Judicial Council immediately for prompt action.
Attempts by the federal government in recent past to tackle issues of graft through the arrest and trial of some judges have failed to yield any satisfactory result, as some of the judicial officers whose homes were raided in October 2017 by operatives of the Department of State Services have been absolved of the allegations. For those still in court, the cases are moving at a very slow pace. Apart from corruption, delay in court proceedings, other problems plaguing the third arm of government includes failure of other arms of government to obey judgments of courts, high cost of litigation, over-reliance on legal technicalities, prison congestion, and poor funding.